The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The spring meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is, Does Taking Control of Your Health Mean Losing Control of Your Data? The Privacy Risks of Healthcare Apps. More and more of us are using apps on mobile devices to help monitor our health. By definition, these apps track how our body is or is not functioning by collecting personal data and doing things with that data that may involve sharing it with others, monetizing it, feeding it to the insatiable beast we call AI, and potentially misusing it in ways that are the stuff of nightmares. How well are existing laws protecting the private data of consumers who use mobile apps to help manage their health and well-being? Do consumers even know what they're agreeing to when they consent to the terms and conditions of a healthcare app? Our guest today is someone with deep knowledge and expertise in data privacy issues and decades of working in all kinds of practice settings, the DOJ, Federal Communications Commission, private practice in-house, and academia. An excellent paper he wrote about the topic of today's episode and other issues related to health privacy is posted on the webpage of this episode, so check it out. But before we talk about that, I'd like to welcome my co-host, Kelsey Paine. Hi, Kelsey.
Hi, Alicia.
Kelsey, would you like to introduce our guest and kick off the conversation?
Sure, I'd be happy to. David Turetsky is a professor of practice at the College of Emergency Preparedness, Homeland Security, and Cybersecurity at the State University of New York in Albany. David has had a long career holding senior roles in business, government, and law. Before joining the faculty, he co-led the cybersecurity, privacy, and data protection practice at a global law firm. And before that, he served as the Chief of Public Safety and Homeland Security Bureau at the Federal Communications Commission. He's also worked in-house as a Senior Vice President for Law and Regulatory at a broadband provider startup as it grew from 60 employees to over 3,000. David's American Bar Association roles currently include service on the ABA's Cybersecurity Legal Task Force and is a co-chair of the ABA's Antitrust Section Privacy and Information Security Committee and vice chair of the Antitrust Section's U.S. Comments and Policy Committee. Regular listeners may remember that David was a guest in 2021 on episode number 104. Have we figured it out? Online privacy and security and the new normal of video conferencing. So welcome back to our Curious Amalgam, David.
Thank you very much, Kelsey. And thank you, Alicia.
So David, to start us off, could you please tell us some examples of kinds of apps and online platforms that collect users' private health information?
Sure, Kelsey. They would fall into a bunch of different categories. They have in common that they all acquire sensitive information about the personal health of the users. And so some examples of those are reproductive health apps. They may track periods, ovulation, fertility, and the like. Mental health apps. They may be used to collect the mental health history and treatment history of individuals and perhaps match them with new providers. Physical and lifestyle apps. We've all heard of those. They track your steps. They track your diet, your exercise, your weight loss, maybe your sleep and other biometrics. Medication and supplement trackers, right? That help us, including the more elderly people among us, to track what medicines they've taken and which ones they still have to take. And then there are devices that have various other kinds of phone apps that can be used They may pertain to insulin. They may pertain to sleep and breathing and things like that. So there is a universe of health-related apps out there that are waiting to collect our information and hopefully provide us with some benefit and some more organization to our lives.
All of these have the benefit to the users of helping them have a larger role in managing their own health. We're less reliant on doctors. And of course, given today's healthcare system, they can often represent a huge amount of cost savings for consumers and patients. But how well is the information that they're collecting about us protected? How secure is it?
I think that varies, Alicia, by the app. And I would break it into two different categories to try to respond to your question. The first is, how well is it protected in terms of the privacy of that information? So who's authorized to have access to the information? For what purposes? And is the app provider meeting their promises and commitments with respect to the use of your information? The second category that I would include is security or cybersecurity often. And in that category, I would talk about the access controls. Do only authorized people have access, and are the security controls reasonably established to protect the data? So you might think of that second category as in, can the data be hacked by third parties? In terms of those two categories, I think there is a range. Some of the apps, I think, are very good. They protect privacy. They do what they say. They don't engage in unfair or deceptive acts or practices. They keep their promises. And some other apps just don't do that. They provide the information for any number of purposes to entities that are not fully disclosed in the privacy policy or otherwise, and they may do it contrary to their promises. On the cybersecurity side, like all companies, there's a mix of standards that are applied out there by different companies, and some exercise reasonable cybersecurity, which is really all we can ask. There's no such thing as perfect cybersecurity in all cases, and some are much less up to the task.
Now, in the paper that I talked about in the introduction that I hope listeners will get a chance to look at, you do have a discussion about the special risks that come with unwanted disclosures, misuse of this personal health information. Can you talk a little bit about why you think those risks are increasing and why the stakes may be higher than perhaps they were before?
Yeah, I think that the answer to that question is really all around us. And that is the changes of law and uncertainties that have taken place in recent years around sensitive personal health information. So let me give you a couple of examples of that. If you go back 3-4 years, Roe v. Wade was the law of the land. What women who consented to collection of their data were agreeing to would have a different potential risk to them in the first or second trimester of a pregnancy than is the case in many states today. Because rather than have a national law, we now have fragmented laws, and they are quite different in different states. And that means that enforcers, and not only government enforcers, but in Texas, there's sort of a bounty system where private parties can file suit against doctors and friends of women and claim they aided in abortions. And so, what you have is a situation where we've got the perhaps same health profile that we had. Sadly, there are so many miscarriages along the way. But what's different now is that enforcers may be studying women's digital history to see what searches online they conducted, when they became pregnant, whether they sent emails that contain certain information, their precise location information, if that was tracked, to see what kinds of clinics they were near. So that's a tremendous change in the risk around information, because before, was a sad event for many women and many men in their lives of a miscarriage, is now the potential subject of inquiry into medicine searches and other characteristics. Another example of that is with conditions relating to gender-affirming healthcare. And, that may or may not be surgical. It may be mental health issues and the like. But we've seen a rapid change in the stigmatization of that and changes in the legal treatment in different states. And so the risks around disclosures of certain types of digital records relating to mental health, to gender-affirming care, are just very different today. And they're different in different states. And even where people have traveled, whether they've gone out of state, may become the grist of questioning and other inquiry. So that's what I mean when I say the risks have changed. If you're a rational person and you're deciding, whether to consent to certain disclosures of information and to provide certain information, it's pretty rational to take account of what the risks may be. And those are very different today.
The other thing that you touch on in your paper, and that's, I think, an equally dynamic, ever-changing situation, is the problem with artificial intelligence and the way it may collect private information and then produce as output what may have been intended to be aggregated, anonymized information, but which might actually reveal something about the identity of the person whose data was collected. Is that something that you think is going to continue to be an issue, or do you think that will get itself sorted out?
Well, I think it's something that we really need to be very careful about. It's clear that AI tools can help tremendously with diagnosis. They can be used to create precision medicines that are tailored to particular bodies and genetic makeups to give you the right amount of medicine, the right frequency to actually help you, as opposed to some standard treatment and standard amount of frequency of medication. So there's a lot of exciting use cases and benefits on the table for AI and help in the medical area. But there are also risks, as you mentioned in the question. And some of those are the data that is used to train AI in the first place. I think that good faith efforts are generally made to try to use anonymized data in doing that. But one problem is because of the tremendous power of AI and to take an aggregate of information from all different places and sort through it and reorganize it, data that was once anonymized may now be de-anonymized. So that's one of the risks. The second risk is that in actually engaging with patient information, once the AI is initially trained, there may be issues that come from the dialogue that it may have with patients about their status and conditions, or even the doctor's notes that are created from a meeting. How do we ensure that that information that the AI is collecting remains confidential? I don't think that anybody is anxious to disclose that or to write or design AI that does that. But, that goes to the testing of AI and to the care and development of it, the extent to which the information that it gathers in doing its work is also used for learning, and what kinds of prompts it may be susceptible to that could elicit information that we would all be horrified to see it give up.
So it sounds like the use of AI could present a risk to companies that are collecting and using this data. Are those companies able to protect themselves by getting consent from the user?
Yeah, you can look at it as a two-sided coin. One is how do companies protect themselves? But the side that I'm most concerned about really is how do consumers protect themselves? And, what is being used now by companies to try to afford themselves protection is the doctrine of consent, the idea that if consumers agree to provide certain information and agree to the storage and certain uses of that information, then the company that has obtained that permission should be okay. The problem, however, is that consent, as it's currently practiced, is a disgraceful mess. Often consumers are uninformed and they are deeply dissatisfied because they don't really have the ability to understand and rely on what will happen to their information after they provide it. Too many companies try to obtain consent, not by practicing the higher standards or adhering to the best practices, but by trying to provide a thicket of information and get the consumers to say yes. Many companies know that consumers aren't even looking at those policies because they can measure how long consumers spend on any particular page and one that provides privacy information before they check the yes box. And I would not blame consumers for this either, because academic studies show that the average privacy policy is something like 2,500 words. That's 10 double-spaced pages. And then when you think about how many privacy policies consumers encounter in a day or in a week or in a month, another study shows that it would literally take months of business days for consumers to read them all. Then there's the question of understanding what's there. Often that's very difficult because the reading level is quite high, number one. And number two, the information, I've tried to read many of them myself, is so vague and imprecise and involves or requires a technical understanding of the different ways data may be used that it's really uninformed. And when you think about people who may not have English as their first language, when you think about people who are older and haven't, grown up with technology and may not understand all of the ways that data may be assembled, you begin to understand why so many consumers are dissatisfied with the way companies obtain consent. There was an experiment in the UK, a gaming company, and for one day, they wrote into their policy that anyone who clicked yes would agree to surrender their immortal soul to the devil on short notice. 7,500 people agreed to that. Nobody rejected that. And I think that is a further documentation that people really can't read these. So what do you do then? How can companies protect themselves, and how can consumers exercise consent in a more meaningful way? And to me, the answer to that is an opt-in system as opposed to opt-out. What do I mean by that? Opt-out means that whatever the companies say is going to happen unless you find a way to knock the train off the tracks. That's opt-out, a way to get out of it. Find the right box to click on the right page and get out of it. The opposite is opt-in, which means the company can't use your data for anything but the narrow purposes to fulfill your requested service from them. And they have to get your permission to do anything else, and they can't deprive you of the benefits of the service if you say no. So at that point, consent really matters. Consumers don't really think it means anything today. But if it's an opt-in, then businesses have to try to persuade the consumer to check a box. And if they don't, then the information isn't used. And, that's a real thing, because Elon Musk, not so long ago, put on X that he was looking for scans and other medical records that he could use to train AI. And a bunch of people took the extraordinary step, really, of sending him their medical records. Well, that's the ultimate opt-in. And, those people meaningfully consented, assuming whatever Musk said he would do with the data and not do with the data was followed.
Well, let's turn and look at the laws now. On the enforcement side, how have the state AGs and the Federal Trade Commission been dealing with these kinds of issues?
The Federal Trade Commission is applying Section 5 of the Federal Trade Commission Act, which enables them to police against unfair and deceptive acts or practices. In many instances, they're sort of the general cop on the beat. We have some specialized cops who deal only with certain subject matters, but the FTC probably, at least under that statute, is pretty broad jurisdiction. It's also got a health breach notification rule, and the FTC has been quite active. It enforced against violations by an app called Flow Health, and that were reproductive and ovulation, a category, a period tracker category that I had mentioned earlier. That was a situation where there were representations made about privacy and how the data would be treated. And according to the FTC, those were not respected, and a settlement was reached. Similarly, the California Attorney General's office brought a case against an app that provided somewhat similar services called Glow on the same basis that their promises about privacy were not being kept. And that case was settled as well. Back to the FTC on mental health, there was an app called BetterHelp that collected mental health history and treatment information from consumers to help match them with providers. And the FTC alleged that the promises were not being kept about how that sensitive data would be kept. So there have been substantial privacy enforcement cases. And one of the prime areas that the FTC has been active in is precise location information, which could reveal whether consumers went to a particular mental health clinic or an abortion or just reproductive care clinic, or to a particular church, or political meeting or the like. And there's a lot of concern about the way consent has worked and the uses of that information. And the FTC has stepped up and challenged some of the collection and use of that information. Another example would be the Massachusetts Attorney General, who a few years ago, even before Dobbs overturned Roe v. Wade, went after a company that was using precise location information to target women who were within a certain distance from a clinic that offered abortions. It was allowing ads and other information to be projected at them. The technique that was being used by the company gathering the information is called geofencing, where they draw a boundary around a particular location and can then target all of the people whose devices come within that boundary for advertising or for other purposes. And so the Massachusetts Attorney General case reached a settlement that prevented the company that was doing that from continuing to do so. So yes, there are a variety of state attorney general actions that have taken place, FTC actions. So it's been a very active area for enforcement.
What about legislative outlook? Have there been any legislative solutions proposed at the federal or state level?
Well, it's interesting that you asked that question, because for many years, there has been a debate over whether to have national privacy legislation that's comprehensive, sort of like the GDPR, the General Data Protection Regulation, that is the law across Europe. In the U.S., we don't have that. We've got various pockets of sectoral, I'll call it, privacy protection. So we have HIPAA, which protects certain health information that is in the hands of doctors and hospitals and their business associates. It doesn't apply to general apps, for example. We have certain financial laws that protect our banking information and our stock holdings and things like that. The FCC, Federal Communications Commission, has some rules about tracking the internet connections that people make. So we have these pockets of privacy regulation laws, but we don't have a comprehensive law. And so that's why the health information that isn't protected by that HIPAA law, because it's not in the hands of doctors and hospitals, it is so vulnerable. So some have urged that we get a national privacy law in place. And a couple of Congresses have come somewhat close to doing that, but have fallen short. And well, some are optimistic that that may change. I am not. I saw the other day that the new chairman of the Federal Trade Commission announced his view that any chairman could be fired by the president. I'm sorry, any commissioner could be fired by the president, and doubtful that in that environment, where enforcement would be subject to the whims of people who specifically are approved by the president for what they're doing or not doing. I just don't see Congress turning over to the Federal Trade Commission enforcement of a new national privacy law if it's only going to be enforced in the way that the president wants, not the way independent commissioners come together and decide to be enforced. So I'm skeptical of that. So instead, what's happened is we've got state privacy laws, and we are getting even more state health privacy laws. The most prominent one of those is the Washington State My Health, My Data Act. And that created quite a stir when it was passed. It protects data that can be reasonably linkable to a consumer if that data identifies their past, present, or future physical or mental health status. And it applies to treatment and disease and interventions and procedures and medication, in gender affirming or reproductive health care info, to biometric and genetic data, even to precise location information that can be reasonably used to indicate a consumer seeking health services. So that's a pretty big deal. Nevada copied them. Connecticut copied them. More states are in line. The Washington law is a bit unique because it allows for private rights of action to enforce that. And that has scared some companies out of the state of Washington. But what you see is, in the absence of federal legislation and in the presence of these concerns about consumers' sensitive health information and the privacy around it, you see states trying to fill that void.
Well, we'll certainly keep an eye out for more developments in this area. I think in the meantime, just as we all have a role to play in managing our own health, we have a role to play in managing our own data as well. So take a few minutes to read the privacy policies, know what you're consenting to, because you're probably the best line of protection for your own health data that there is. Thank you so much for an interesting conversation. And thank you, Kelsey, for helping us with this interview. Before we let you go, David, however, we're going to ask you a question we'd like to ask all of our guests to get to know you a little bit better as a person. Can you tell us something interesting or unusual about yourself that is completely outside of your professional life?
Well, given that I'm sitting in a place surrounded by almost a foot of snow on the ground, I would say that one thing that is a bit unusual is how much I like to swim and do it year round. I swim multiple times a week indoors and do at least 1.25 miles each time I swim. So that would be something a little bit different, especially with snow all around.
Have you been a swimmer your whole life? Did you do it as a team sport when you were younger?
I did. I was a competitive swimmer as a teenager. My coach said I was pretty good until I started politicking.
And finally, David, we're going to play a little game we call The Curious Hat.
And now it's time for The Curious Hat.
The rules of the game are extremely simple. I'm going to ask Kelsey to draw a surprise question randomly from our virtual hat. So take it away, Kelsey.
So continuing along with the snow everywhere theme, it's currently February and the weather is pretty cold and dreary in most places. So in honor of everyone looking out their office window and dreaming of beaches and better weather, what is your favorite travel destination?
Wow. Well, I like beaches, Kelsey. So very far from this environment. And I would say that's the common element. I like them wherever they are found. And there's warm weather that accompanies my trips to those. So whatever isn't like this. I've loved beaches everywhere from other countries like Australia and Greece to ones in the U.S. in New Jersey and California and in Maryland and Delaware and other places. So that would be my answer.
Well, I hope you get a chance to get out there and enjoy the beach and the waves. Thank you, David, and thank you, Kelsey. Thank you to listeners, and join us for the next Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.